Welcome to Lawsplaining. This is a YouTube channel that endeavors to lawsplain legal concepts with a dose of sarcasm. Today we're going to lawsplain the legal parameters of abortion in Kenya. The World Health Organization has aptly stated that unsafe abortions are the leading cause of maternal deaths here in Kenya. This is partly due to restrictive abortion laws that impede on women's right to access high standard of healthcare. A further reason is that women's bodies have long been instrumentalized for cultural, political, and economic purposes rooted in patriarchal traditions. This contrivance is embedded in the health sector and acts as a bulwark to women accessing healthcare and in maintaining autonomous decisions over their bodies. The criminalisation of abortion in Kenya is espoused in Section 158, 159, and 160 of the Penal Code. The Kenyan Constitution, however, in Article 26(4), espouses the legal parameters of abortion in Kenya. This is in the instance that where it's in the opinion of the trained health professional, where there is need for emergency treatment, or where the life of the mother is in danger. Kenya has also ratified international legal instruments such as the Convention on Elimination of Discrimination Against Women and the Universal Declaration on Human Rights, amongst others, which promote and reaffirm reproductive rights of women on the enjoyment of the highest attainable health standards. Now, we shall delve into the three key players with whom these restrictive abortion laws actually impinge on. We'll start with women. The right to life is antecedent to all other rights enshrined in the Constitution. However, the right to life is not absolute, as enshrined in Article 26(4), in which abortion is permitted. Access to safe abortion services is a human right. The lack of access to safe abortion services prompts women to resort to unsafe abortions in which they risk their life, persecution, and punishment. The World Health Organization states that the lack of access to safe, affordable, timely, and respectful abortive care and the stigma associated with abortion poses a risk to women's physical and mental well-being. Therefore, with regard to safe abortion services, women have a right in Article 41 and 42 of the Kenyan Constitution to the highest attainable healthcare standards and the right to emergency medical treatment. Women need to be endowed with a knowledge of what encompasses the reproductive health rights. These rights include, but are not limited to, the right of access of information regarding family planning and reproductive health information, the right to information regarding surrogacy, artificial insemination, and validity of those agreements, right to safe motherhood, including antenatal care, delivery services, postpartum care, and sterilization, the right to termination of pregnancy, which includes prior consent, abortion procedure, and post-abortion care, the right to privacy, confidentiality, inherent dignity, freedom from torture, cruelty, inhumane, degrading treatment, and discrimination, counseling on female genital mutilation and treatment of HIV and AIDS, and lastly, information regarding the consequences of unsafe abortion. Therefore, women have a right to access healthcare services that promote their health and safety, autonomy over their bodies, protection against criminalization. We're going to delve into the second key player. The criminalization of abortion impinges on health professionals who are often profiled by police authorities for procuring abortion, albeit safe abortion, due to the public perception of a blanket ban on abortion. A health-trained professional who is of the opinion that an emergency medical treatment needs to be performed in the procurement of abortion must be guided by the Health Act No. 12 of 2017. Before a health professional procures abortion within the parameters of law, he should be guided by three principles. That is the principle of prior informed consent, the principle of privacy, and the principle of confidentiality. In Section 9 of the Health Act, the health provider is mandated to seek prior informed consent of the patient before such medical treatment is conducted. In the case of a minor, a guardian is the one who's supposed to give consent. Needless to say, the best interest of the child should be paramount. In regards to the second principle, that is the right to privacy, it engenders a cluster of rights which include but are not limited to the protection of women's right to inherent dignity, autonomy, access to information, bodily integrity, respect for private life, and the right to highest attainable standards of health, which include sexual and reproductive health without discrimination, torture, cruelty, inhumane, and degrading treatment. The last principle is the principle of confidentiality. Health providers under Section 11 of the Health Act number 21 of 2017 have a mandate to maintain confidentiality and not disclose patients' confidential information, which includes but are not limited to the health status, treatment, or stay in a health facility. Such information can only be disclosed upon the patient's waiver to such disclosure, upon a court order or any applicable law that requires the disclosure, or where the non-disclosure of such information would represent a serious threat to public health. It should be noted that the practice of interrogation by healthcare providers, police, or judicial authorities is a violation of women's rights to privacy and confidentiality, devoid of the due process of law. Moreover, the legal onus placed on doctors and health professionals to report cases of women who have undergone abortion fails to respect women's right to privacy. Women have an underogable right of access to emergency medical treatment for a condition representing a danger to their health or life without fear of criminal charges. In that same breath, health-trained professionals who procure abortion within the legal parameters are not within the ambit of the criminal offense espoused in Section 160 of the Penal Code, as they lack both the mens rea and the actus rea. The state is the last key player and has been unyielding in the promotion of women's reproductive rights while simultaneously promoting derogation of women's rights through arbitrary arrest. Here is a survival guide on how to counteract the state in procurement of safe abortion services. In the instance that any woman or trained health professional are arrested over the allegations of procurement of abortion, they should assert their rights of arrested persons in Article 49 of the Constitution of Kenya. These rights include, but are not limited to, the right to be informed of the reason of their arrest, the right to remain silent, the right to communicate with an advocate or other person who shall offer assistance, the right not to self-incriminate by being compelled to make a confession or admission during police interrogation, the right to access to medical treatment, in this case post-abortion care, and the right not to be forced to undergo forced medical examination, which violates the rights of women, and to have such evidence that was obtained during the forced medical examination to be adduced at trial. The state should not interpret Section 158, 159, 160 of the Penal Code as a blanket ban on abortion in Kenya. However, the state should apply the evidential test and threshold test to establish factual and legal foundation to disclose a prosecutable offense. The rule of law should be applied in criminalisation of abortion. The offences should be read and implemented in a manner that doesn't impede on the enjoyment of reproductive rights accorded to women. Women have a right to the highest attainable standards of health, which encompasses the protection against vexatious vicissitudes of pending criminal accusations and the social costs that are attributed to those sanctions, such as the loss of privacy and the stigmatization of the accused. Lastly, we should lobby Parliament to pass the Reproductive Health Bill that was sponsored by now Governor Susan Kihika. And I must issue a disclaimer. Whilst the information purveyed contains legal insight, it should not be construed as legal advice and the creation of an advocate-client relationship.